I'm going to put you in a lockup. If you can't sit there without making any noise, you'll be removed from the courtroom. Do you understand that? You don't talk. Because I'll remove you from the courtroom. She said she stepped out of the front door onto the porch. Your client came out and they had the confrontation on the porch.
If I may.
No, you can't. I got 6 exams today and I don't need to hear the same stuff 4 times. Ask a new question that elicits new information.
My name's Zach Coleman. I have a few questions for you today as well. If you don't understand the questions I have, which is entirely probable, just re-ask or ask me to re-ask the question. Please. Don't try to guess. Mr. Kaplan will take care of you in that regard too. Isn't it true you lived as Ms. G's neighbor for over 3 years?
Yes.
And in that time, since you've lived with her, is it fair to say that there was a period where you were more amicable with her than you are now?
Factor relevancy doesn't establish an element of the crime or disprove an element of the crime. They can be best friends or mortal enemies.
If Your Honor, if I may continue with the line of questioning, you'll see where I'm going with this.
Without a response to the relevancy objection?
I think it's entirely relevant. It goes to the reason that the complaining witness made the call to the police. It goes to the nature of why the matter escalated in the first place that day, as to what she saw, as to what other complaining witnesses saw. I think to narrow it down to the element of whether Ms. G had a taser that day or not is a little too narrow for the scope to that response.
Your Honor, she either pointed the taser at her or she didn't point the taser at her. That's what we're here to discuss. We're not here to determine whether they're best buddies or mortal enemies.
In fact, though, Your Honor, we are, because one of the essential elements described is whether Ms. Sixby was truly afraid of her life. So if she doesn't know her at all, as she testified, or whether she does know her, and this is just an issue between the two of them, where she knew that Ms. G was actually not going to go retrieve a gun and fire it at her, but it was a continuing issue between the two of them, then that does impact Ms. Sixby's state of mind, whether she was in fear of her.
Go ahead.
Sorry.
No, you're right. Go ahead.
One is assault can be proven one of 2 ways. It's either an attempted battery or an attempt to place somebody in fear of suffering a battery with a dangerous weapon. So I don't see how this inquiry acknowledged that this inquiry proves or disproves anything. Controversy might be interesting. Maybe a jury wants to hear the details, but you don't need to know those details.
Then, Your Honor, it goes also into Ms. G's state of mind. And whether how well they know each other, it is absolutely relevant to what Ms. G intended that day.
I don't think her state of mind is relevant at all. It's whether or not the alleged victim was put in fear.
Well, then I stand by my previous response. I do think that the level to which she knows Ms. G, if she had just moved in, she's never seen her before, or if she's seen her as her next door neighbor for the last 3 years, is relevant as to whether she was in fear for her life.
I'll allow very limited questioning on that specific issue. What this witness knew about that lady's propensity for threats or violence, because that's what you're saying.
Thank you. So, Ms. Sixby, let me back up before we got a little sidetracked. I think my last question was, you've lived next door to Ms. G for 3 years, or over 3 years, right?
Yes.
And so over that time, how many conversations have you had?
Probably
Objection
5.
as to relevancy.
Probably 5.
Like 5 or
Okay.
Sharon's thought.
All right. How many conversations she's had?
Oh,
You don't talk, because I'll remove you from the courtroom. The issue is whether or not she thinks this lady has the ability to make if a threat is serious. That's what you were relying on, right? Okay. So whether or not they've had 40 conversations or 4,000 conversations doesn't get you there. Not in a limited light of questioning. So maybe you got to ask her specific questions about threats or violence.
Has Ms. G ever before the date that we're talking about here made any threats or objection?
It's not relevant on the day in question. That's what we're concerned with.
I'll allow it. I'll allow it on a limited basis.
Yes, before the day in question.
I wouldn't say threatened,
Okay,
that I know, like, I didn't know her like that. The first time I met her, she called the cops on me. Because she said I parked in her parking spot. I've always tried to stay away from
Story, none of
her.
this is relevant.
Yeah, let's move on.
I did not.
Okay, there's no question.
okay, Your Honor, I believe Mr. Catlin interrupted when she was answering the question that I posed to her. And,
She was talking about your client calling the cops on her because of a parking violation.
right, and I believe before that, you were interrupted, you said that you've had about 5 conversations.
Very limited conversation.
Well, I'm asking you about those limited
And
conversations.
we object as to relevance.
And in those limited conversations, your testimony is before the day that we're testifying about today, she had never made a threat towards you.
Objection as to relevance, he's not an element of the crime.
I'm allowing it.
She has not threatened me, but she has done stuff to try to provoke me. That's what she always has been doing, and I kept forgiving her. I just want peace.
What was she doing to provoke?
Objection.
Okay, okay, ma'am. I don't know, maybe you've never watched a show on TV where there's a trial. But when an attorney stands up and says object, the witness doesn't talk,
Okay.
okay? Make your objection. Response.
Your Honor, I think if I can request for an instruction, if we're gonna get the same objection, please to Kaplan, every single question, it is an essential element of the crime. I am keeping my questions very limited to what you narrow the scope of this line of questioning to, and we're still getting an objection every time. It seems like we're clearly trying to interfere with the complaining witness's testimony. I'm asking very specifically about her frame of mind on that day. That is contextualized by the history she has with my client.
I'll allow it.
What would my client be provoked?
Smear hamburger on my front door after I went to work.
When did that happen?
Your Honor, we object, these are prior bad acts under 404B, and they're being introduced against her, his client.
If he wants to introduce him, let him. I get to decide that today.
And she has followed me. I got to make a police report after what happened, because she was following me and my daughter twice.
And when in proximity to the day in question that we're testifying about today, did the 2 incidences that you just described, to the best of your memories?
When did they happen?
Yeah.
About a week ago, 2 weeks ago.
Okay, so did this, my initial question was, times you interacted with Ms. G, my client, before the day in question. Okay.
We object, it's been asked and answered, and it's also not relevant.
And it's confusing. So this incident happened in January. Yes, ma'am?
Yes,
The taser incident.
yes,
The incident with the hamburger and the following, was that before January or after January?
before.
Okay, about 2 or 3 weeks before?
No, about a year.
Move on.
Okay, so any other incidents of provocation that the term of use from my client besides the hamburger, hiding window, the incident of stalking where you call police?
Things after,
Before January.
Well, I'm sorry, before June.
there was incidents where she would be like trying to provoke me, or she would try to get information out of me, apparently because of the stuff that she was saying on the day of the incident, of information that she knew, and the only way that she would know that information is if she was following.
Okay. Yeah. My initial question, yes, I agree with Mr. Dickens, it's no longer relevant. But just to close this line of questioning, was there any other incident with that, let me re-ask, besides what you've already testified about, before the incident in January, did you have any other interactions with my client where she either provoked you or allegedly threatened you? Okay. Were you looking for a reason to call the police on Ms. G?
No,
Why did, on the day in question, in January, isn't it true that your mother-in-law was involved in these?
Judge,
Or
that's the problem.
I don't have a mother-in-law.
the,
Objection, ask
Okay.
the see.
Okay.
Doesn't prove or disprove anything in controversy.
well, actually, Your Honor, the response is, I move you to the day in question. And there is another witness, and I'm sorry, it's a familial relation, and I'll correct the record. But absolutely, she was involved. She bore witness to Miss G being there. And my line of questioning is about where ultimately the complaining witness was when the alleged threats were.
We have a trial within a trial.
Yeah.
You look
And
at,
she's already testified that they were approximately 6 or 7 feet away when the taser was involved. So I don't know what more you're going to get about proximity.
Well, then let me narrow it down, please, Your Honor.
Try.
Thank you, Your Honor. It is, my line of questioning is specifically, where were you in terms of your proximity to your doorway of your apartment when Miss G allegedly threatened with her taser, alleged taser?
I was on my front porch next to my front door by the farthest, right here. So I just walked out.
You had just walked out of your porch.
I just walked out of my house.
Onto your front porch.
Yes, onto my front porch.
Thank you.
Wow.
So you had just walked out of your house onto your porch.
Judge, any yes and answer?
Good hands. Go ahead.
And was that the first time you saw Miss G with what you believe was a taser?
Yes, because she's acted at me.
Hold on, if you could just answer the questions that I asked you, please. When did she at it?
She walked outside. She walked outside screaming, talking about she had a gun in the house. She was going to shoot me with it, and she had the taser in her hands, and she's acted 3 times that day.
Okay, that was when you came out of your house.
Yes.
So
Your Honor, excuse me.
where was it?
I'm being distracted by the.
Yep. I'm going to put you in the lockup. If you can't sit there without making any noise, you'll be removed from the courtroom. Do you understand that?
Okay, so my question really was, when did Miss G threaten you with the taser? Was it before you went into your house? After you went in, you came back out of your house, both?
She said she stepped out of the front door onto the porch. Your client came out and they had the confrontation on the porch.
If I may,
No, you can't. I got 6 exams today and I don't need to hear the same stuff 4 times. Ask a new question that elicits new information.
okay, where was Miss G when she threatened you with the taser?
On her front porch.
Where in proximity to your house is her front porch?
Like
6 or 7 feet away. Sit down. You're done with cross. Do you have any redirect?
No, wait a minute.
Thank you.
Put my objection on the record.
Feel free. Any other witnesses? Any defense witnesses? Any argument?
Yes, Your Honor, the witness testified a taser was pointed at her distance of 6 to 7 feet. She was afraid, actually fearful for her life. Thank you.
Your Honor, we don't believe the elements of felony assault with a felonious weapon occurred here. We believe, if anything, the charges should be dropped to misdemeanor assault. And we asked that he would find that the prosecutor did not meet his threshold for a preliminary exam and would not find so. Thank you.
Because there was no testimony about a felonious weapon?
Your Honor.
I'm not familiar with what a felonious weapon is.
Your Honor, I would have gotten into more details regarding what what our lovely complaining witness perceived the weapon to be. I will reserve that argument for circuit court. I don't believe that it's a felonious weapon in this case.
Okay, I don't even know what a felonious weapon is. Is that the same thing as a dangerous weapon?
I don't believe that it meets the definition of a dangerous weapon, making this a felonious charge.
Okay. Bound over. AOI is next week, 9 a.m.
Thank you, Your Honor.
Say again? What? Oh, yeah, you can step down, ma'am. Watch your step. What is today?
Today is the 19th.
Yeah, so 26. No. Yeah, yeah. No, she's in custody. Oh, she not? Oh, she had green on. I thought. Okay.
DOC could be dismissed, so we can pull that one and get it done.
Who? What's the name? Okay, what about Avant, the 945? Avant, 945.
I was going to get into that, but she's very close, ready to go.
Who?
Steps in,
You just get her in here. So it's going on an hour.
Yeah, it's good, going on.
Who changed the date stamp today to the 20th?
I'll throw on the question Joe to do his problem himself. Here, you're right.
I have, okay.
Hey, Carrie, how are you? Better than I deserve, Carrie.
Judge.
Appearances on Avant.
Good morning, I got 12/85/68, and that is the state of the state and directly.
Good morning, sir. Counsel, you got a plea worked out? Tell me about it, please.
Unlawful transport and dismissal of the original one on it,
Yeah, we only had one count, right? All right.
no comments. And I.
That was my next question. All right, sir, do you understand your rights and your options after discussing same with counsel? And you understand the possible penalty for the added charge? All right, and understanding that you're pleading no contest today, is that correct? Do you understand that when you say no contest, you're literally saying to me, Judge, I'm not fighting that charge? You understand that? All right, counsel, I've got an incident date of April 6, 2025. If you can get me the facts I need.
Thank you, Your Honor. Your Honor, if this case were to proceed to trial, the people would be able to show that on April 6th of 2025 on Ecorse Road and Harrison Street in the city of Romulus, County of Wayne, state of Michigan, that Andre Avant did possess a weapon in a motor vehicle without the proper permits or licensure to do so. And transporting that not according to law.
Okay. Mr. Kaplan, you satisfied?
Yes, we are making.
Factual? Court satisfied. I'll dismiss the original count one felony. Any reason not to sentence right now?
It's something.
All right. Tell me something about your guy.
court would consider fines and costs in this matter. My client's only criminal history is from 22 years ago. He owns his own business. He has a partner. He has children. He has been a law-abiding citizen except for this, which he told me he was in possession of this out of state. Realized when he brought it back from that trip that the laws differ state to state, since he was able to pick this up in a gift shop. So now that he knows that, this won't be happening again, Your Honor.
Okay. What's your business? I'm sorry. Go ahead, Mr. Capel.
See, Kevin, thank you. At the age of 47, he has no criminal record other than these offenses that happened 22 years.
Yep. Yep. I think he just took your side.
Judge, we're recommending.
What business are you in? What do you do? Okay. Okay. Who do you deliver for? Are you one of those guys like delivers for Home Depot and stuff?
For whatever, yeah.
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 Okay. Okay. All right. Don't feel that you have to, but is there anything you want to tell me before I sentence you?
No.
All right. Counsel, anything else?
Your Honor, I think it's fine.
I do too. All right, fines that cost you $500. Can you pay it today, sir? Or do you need to talk options? Go downstairs and talk about your options. All right, felony's dismissed. Have a good day, counsel.
Thank you, Your Honor.
You're welcome. What do we got next?
Devontae Hadley.
And appearances on Hadley.
Stephen Kaplan on behalf of the people.
And good morning, Judge Oakley, good morning to your staff, David Defendant Service, Perry Markin, P 84592, representing Devontae Hadley, sitting to my left. Tell you for.
Thank you. Sit. You're all right, sit. We holding?
I mean.
Yeah.
Thank you. I'm here with Detective Nays. He has made yeoman-like efforts to produce our witness. We're both disappointed the witness is there. I don't want to waste your time, Chuck. If you might have me to state on the record the opportunity.
Yeah, go ahead, detective.
I reached out to one of the enterprise personnel people based on they were with this case that an employee no longer works there and they had a relatively common name, therefore I was unable to locate them through every database that I used. The party involved, I believe, actually was a third-party contract that was transporting the defendant, and I contacted him. Did speak. He was a little standoffish, if you will, and asked me to call him back, which I did, and he never answered. So all attempts have failed. My apologies for that.
All right. Motion?
Your Honor, obviously the people are not ready to proceed. We would move for dismissal without charges.
Dismissed without. Good luck. Thank you.
So on the strangler case,
Mhm.
we've got a victim,
Mhm.
no defendant. And
That's curious too. Okay. Yep.
I don't know if we have the attorney.
Hey, Carrie. Any contact with Stringer?
She should be here. She told me she had a flat.
Ah, okay.
Yeah.
Okay. But you've been in contact.
Yes.
Okay. What about Fonville in custody, right?
He's in custody.
We're just
I don't know
waiting
if
for the attorney?
it's here yet.
Okay. All right. Thank you. Oh, that's right. She's the retail fraud. That's what's
All the way down before the time, that's something.
Oh, wow.
My client is a big, no contest plea.
Okay.
And
You satisfied with the facts, Mr. Kaplan?
This report reflects that on the date shown in the complaint, Judge, this young lady, the defendant, visited a home, not her own, caused a slight amount of damage to the front door, and also tried to enter the home unsuccessfully without permission.
Satisfied? I am too. I'll dismiss the original count one. I'm inclined to send her for a pre-sentence investigation, but I'll let you try to talk me out of it.
What I feel, if I may, is that this was an isolated incident. It was actually a mistake. I think maybe she was associated with a bad hombre somewhere, but at any rate, she seems to be doing well. I think you could set this straight.
I agree, Judge.
Okay.
This $500 restitution that's set there. I believe that you can come up with a reasonable probation on the spot and speak.
Okay. All right. Go ahead.
Your Honor, Ms. Stringer is 20 years old. This is her first contact with the time system. Like Mr. Kaplan said, I think this was an isolated incident. She has worked before. She's looking for work now. I think this pending has made it difficult for her to secure her next job. She intends to, re-enter the workforce.
Okay.
We're grateful for the misdemeanor reduction. Hope that these offenses get expunged sometime soon. In the meantime, Your Honor, we would ask for simply imposing the restitution that was in the agreement. If there would be any probation, that it be minimally intensive. She lives in Taylor.
Yep.
So not exactly stone's throw away. So I would just ask that any probation be limited to, a few check-ins, maybe, alcohol test.
Gotcha.
Intensive classes, or anything like that.
We agree, Your Honor.
All right. Thank you. All right. Ms. Stringer, where did you work last time you had a job? Who were you working for? How long were you there?
It started like 2-3 weeks before.
Okay. How about the job before that? What were you doing? Okay. All right. So this is a little bit off topic, but before you leave my building, go downstairs and ask if Mr. Taylor's still here. He shouldn't be at lunch yet. Ask Mr. Taylor what he's got for job opportunities in the area, like Romulus or Taylor. He keeps track of job openings for like entry-level jobs. He's usually got a pretty good list, so something might reach out to you. All right. Anything else you want me to know before I sentence you today? No? I can't hear you. Okay. All right. So I've got a problem with these restitution orders. Do you have the ability to pay $500? Not today, but I mean, can you get this paid in the next 5 months, 6 months? You sure? All right.
Your Honor, the average,
Yeah.
we recommend a $300 restitution.
$300?
More assessed, how much damage?
All right. It's your recommendation. I'll take it.
Thank you.
She's not going to argue with you. All right. So you can get that done? Okay. Was there any indication there was some kind of substance abuse involved in this?
No, don't do so, Judge, thank you.
You got a driver's license, your valid license to hold 9 yards? Okay. All right, well, the $300 has got to be money because that's restitution. I'll give her the option. I could do some community service or I could do some work program time instead of fines and costs. She's not working right now. She just have to be here at 8 o'clock in the morning. She picks the days.
So that would be work program as opposed to community service.
Well, I like work program because then she walks out of here. She knows she's got a schedule for X number of days. She bangs those days out. She doesn't have to worry about finding someplace to go. She just shows up here and does it. I'll give her fines and costs and give her time to pay.
Could we just do one in lieu of the other so she can kind of choose?
All right, so here's what I'm gonna do on 750.3806. Well, first of all, on both charges, it's 12-month non-reporting probation. That just means stay out of trouble. On the first count, which is the 3806, that one, I'm gonna put the restitution on that file and $400 fines and costs or 4 days on the court work program. On the attempt illegal entry, it's another $400 fines and costs or 4 days on the work program. What I'm inclined to do, counsel, is give her until June 12 on the first file to do the money or the work days, and then give her until July 15th on the second file. So that way she just knows she's got 30 days to either do the $400. In any event, she's got to get the 300 paid, but she's got the first file, she's got 30 days to do the 4 days or the $400, and then she's got another 30 days to do another 400 or another 4 days. And if she wants to pay 4 and do 4,
That we appreciate, court's, assessment here. Is it possible just give a little bit more time? What if we just make it like a, instead of a 30, 60 day, make it a 60, 90 day situation?
no, I'm not gonna wait that long to find out I got a problem. If she wants to say, I'll do the money, then we'll just put her on a payment plan on the money. If she can't make the decision today, I gotta limit it. But if she wants to make the decision today, money or time, then we can work with that. But why don't we pass on this so I can call another file? You guys take all the time you need. Fonville,
That's it, you sir? David Champagne. Thank you, David.
appearances on the People versus Fonville, please.
Or Sandy Allen on behalf of the people line.
Good morning, David. The defender serviced by Ashley number 87788 on behalf of Mr. Fonville. Mr. Fonville, will you please state your name?
Joseph Fonville.
Thank you, sir. What do we got?
If we're ready to proceed, we are seeking respectfully to call Denise Fisk by Zoom. Judge, in this case, Ms. Fisk is not in the state, it's outside of the state. The court rule, Judge, I know you're familiar with it, the criminal court rule gives your honor absolute discretion to allow testimony by Zoom, and you know that, I know. Then the only stipulation or mandate is that the defendant either attend court or refuses to attend court.
Right, counsel.
Your Honor, at this point, the defense objects to Zoom testimony and asks for a dismissal of the charge instead because the witness is not here to testify. The court rule that Mr. Kaufman is referring to, of course, is FCR 6.006, which refers explicitly to its civil equivalent, FCR 2.407. 2.407 lays out factors for Your Honor to consider when allowing Zoom testimony versus not. A couple of those key factors here are the opportunity for full and effective cross-examination. As the court knows, a transcript is produced, and say we get to trial, the witness is not available then, and the government wants to proceed just on a transcript. That's a confrontation issue, and today is not a full and effective opportunity for me to cross-examine Ms. Fisk because I can't see her body language. I can't see if she has papers on her lap or on the table. I can't see if there's someone behind the camera coaching her testimony. And so cross-examination is therefore limited when we have to do testimony. Another one of those factors is whether there is physical liberty at stake. Obviously, Mr. Fonville is in custody and his physical liberty is at stake in this case. And finally, another key factor is the convenience of producing the witness. Ms. Fisk doesn't live out of state, doesn't work out of state, she is on vacation, and that's something that the government should have planned around. at the PCC stage when we were scheduling this exam, rather than on the day of the exam. So for all of those reasons, we would ask for a dismissal and lieu of testimony.
Thank you. Yeah.
There are 6 of them in confrontation where it's a trial right now, preliminary examination where the U.S. Supreme Court has so held on many occasions. Now, the Michigan Supreme Court devoted an abundance of effort in devising this rule, which is MCR 6.006 parentheses 4. And I'm not going to repeat what I said earlier, but the court gives you discretion, Supreme Court gives you discretion. Now, let's assume that Judge Oakley decides, let's have the witness. All right, case dismissed without prejudice. He'll be rearrested, he'll be rearraigned, and we'll try him then. Judge, I don't see any prejudice or experienced attorney with the cross-examination witness.
All right. Anything else?
Nothing further.
All right. Thank you for your arguments. I'm going to allow the testimony today by Zoom. Ms. Fisk, can you raise your right hand for me? Do you swear or affirm tell the truth, the whole truth, nothing but the truth today?
I do.
All right. Looks like you can put your hand down, ma'am. Looks like you're in an automobile.
I am.
Are you alone in that automobile?
I am not. We're on our way back to Michigan.
I'm say that again.
We're on our way back to Michigan. We're in
Okay. All right. So I'm assuming your driver has nothing to do with this case or your employment?
No, he does not.
Okay. All right. Are we ready, Mr. Kaplan? Go ahead.
Thank you, Brian. Judge, I missed it. Swearing the witness.
I did.
Thank you, Judge. Good morning, Ms. Fisk. Can you see me?
Good morning.
Can you see me?
Not great. No, I can't actually.
Should I move? I go to the
Try the podium.
Ms. Fisk, can you see me?
Yes, I can.
What do you do? I know we've been Steve Campbell with the prosecutor's office. Ms. Fisk, where are you employed?
Meyer in Belleville.
How many years have you been working in Myers?
34.
What street?
Pardon me?
What street is the Meyer located on? The store.
Van Buren Town.
What is your current position with Meyer?
Sorry, could the witness repeat her last name, sir, for audio file?
Ms. Fisk, give me that address again, please.
The address is 9701 Belleville Road, Van Buren Township.
Thank you.
What's your current position, Ms. Fisk, with Meyer?
I'm a store detective.
Can you estimate for Judge Oakley the number of cases you investigated involving shoplifting at retail stores?
In 34 years?
Are
I couldn't even guess.
we talking hundreds, thousands? What are we talking?
Oh, yes.
I'd like to take you back in time to April 29th of this year, 2026, at about 2 p.m. Were you working?
I was.
Did you have the opportunity on that day to meet a gentleman or see a gentleman named Joseph Fondle?
I did.
Did you see Joseph Fondle?
Pardon me?
First, see Joseph Fondle.
Objection, there's a lack of foundation as to how this witness could identify any individual as Joseph Fonda.
That's a cross-examination. She could testify, she knows them, and
It'll work for Cross. Go ahead.
thank you. Regarding Joseph Fondle, where did you first see him on April 29th, 2026?
In our liquor aisle.
Where were you when you saw him in the liquor aisle?
I was in our camera room.
Describe the liquor aisle to us.
It's an aisle, several feet long with liquor.
Now, on that day, was your store giving away liquor to people?
No, they weren't.
You said that you were able to observe this through surveillance. Can you describe the surveillance to us?
It's closed.
Go ahead.
Pardon me?
Go ahead, describe it.
It's closed circuit television. We have cameras throughout the entire store.
Were the closed circuit televisions working on this day of April 29th? Were they
Yes.
functioning properly?
Yes, they were.
How do you know that, Ms. Fisk?
I was working them.
Ms. Fisk, if you saw Joseph Fondle again, do you think you'd recognize him?
I would.
How does she look around the courtroom, you know? look around the courtroom.
Well, she's looking at everything you're looking at on that screen in front of you.
Look around the court and tell us whether you see Joseph Conville.
I'm having a hard time seeing in the courtroom.
Can we show the council table?
I don't have the ability to do anything with this.
I can't zoom this screen actually.
I think it's zoomed in as much. The whole courtroom is zoomed in as much as it can.
Yeah, this is what we got.
That's the main courtroom.
That's helping a little bit.
And then do the other.
I mean, I'm terribly sorry. I can see two people, but I can't see it to.
Ready, wait a minute.
I am going to object to identification.
She's got it zoomed as much as it'll zoom. So hold on, guys. It's zoomed as much as it'll zoom. Go ahead.
Going to object to identification at this point in time. I think all the court has done, all the court can do in this particular instance is literally zoom in on my client, and that is incredibly suggestive as to who this witness is supposed to identify in the courtroom. It also looks, based on the portrait orientation of Ms. Fisk on Zoom, that she is on a phone, which is a small device that's also supported by the fact that she is in a car. That's a small device. She said she can't zoom in. I expect that her ability to see, even though the court has zoomed in on my client, her ability to see is limited. Any identification would be incredibly suggestive and unreliable, and so I ask that the court decline to make it.
Well, of course, counsel presupposes that she knows my case. I might have another witness who can identify. I would like to proceed with this witness.
Go ahead.
What she knows.
Go ahead.
Ms. Fisk, can you describe the person you saw on CCTV?
A black male, dark glasses, like black rimmed glasses, wearing all black.
Had you seen him before at your store?
I had not.
What did he do, if anything, while he was in the liquor aisle in Meyer?
Pardon me?
What did he do while he was in that liquor aisle at Meyer?
He selected liquor and placed it in his cart, and he's
Pay is limited right now.
Sure.
So talk about the ability to do work program.
Yep.
8 days by July 15th. And Ms. Stringer will go with that option.
Okay.
Did you just want some clarification about this $300 restitution?
Yeah.
You said a 12-month non-reporting probation and, 300 must be paid by the end of probation.
Well, I want it paid before then if she can, but I understand she's not working right now. Right.
Or there's not a specific deadline that the court is.
I mean, I'll put her on a payment plan. What do you want to pay? How much? How often? Make some kind of commitment and we'll set that up. Okay. And then you can always pay it off early. And if you get a really good job before you're done with your 8 days and you want to pay money instead of doing the days, we'll convert there. All right.
So I think the whole sentence would then be 12 months non-reporting probation, $300 restitution on a payment plan, 8 days in the work program, first 4 by June 12th, next 4 by July 15th. That's it.
First 4 by when?
You said June 12th.
Okay. I thought you said June 4th. I'm like, no, that's too quick. Okay.
June 12th, and next 4 by July 15th. No other terms or conditions.
Yeah. Stay out of trouble. That's what probation's all about. Okay. Anything else?
Nothing.
All right. Go downstairs, make arrangements for that $50 a month. And we'll always take money early so you can get out from under that quicker.
Thank
You're
you.
welcome. You're welcome. Always a pleasure, counsel. Shutting down.
Yes.
Joe, you want to turn that TV off? Yeah.
She kept zapping the taser at me, and the courtroom instantly turned chaotic. A terrified neighbor testified that a woman stormed outside, pointed a taser at her from just a few feet away, and threatened that she also had a gun inside the house. The witness said she was so scared she had to escape through the back door of her own home. But the defense attorney fought back hard, arguing the two neighbors had ongoing drama for years and claiming the alleged victim may have overreacted because of personal tension between them. That's when the judge finally snapped, warning people to stop interrupting, threatening to throw someone out of court, and shutting down repeated arguments from both sides. Then came the big moment. Despite the defense insisting a taser wasn't a dangerous weapon, the judge wasn't buying it at all. The defendant was officially bound over on the felony assault charge, leaving the courtroom in complete silence. Do you think pointing a taser should count as felony assault?